case briefs, and so much more. LSData's got what you're looking for.
The New Jersey Superior Court, Appellate Division, in 2001 heard a case, Associates Home Equity Services Inc. v. Troup, focusing on lenders' responsibility to follow certain rules when offering loans and borrowers' legal rights to challenge predatory or illegal lending practices. Beatrice and Curtis Troup acquired a mortgage loan from East Coast Mortgage Corp, ECM, for home repairs but fell behind on their payments, leading Associates Home Equity Services Inc. Associates to file for foreclosure. The Troups accused Associates and ECM of violating state and federal laws and filed a counterclaim and a third-party complaint against them and the home repair company, Wishnia. Initially, the trial court dismissed all claims against Associates and ECM, granting a foreclosure judgment in favor of Associates. However, the Troups appealed the decision, and the court found that genuine issues existed regarding predatory lending by Associates and unconscionable business practices under the Consumer Fraud Act, CFA. The case also dealt with the Holder Rule and affirmed the trial court's Truth in Lending Act, TILA decision, and the $50 disbursement fee charged by ECM's attorney. Ultimately, the court upheld the dismissal of the Troups' rescission request and found the $50 fee to be not undisclosed. However, it reversed the consumer fraud claim dismissal, allowing the Troups to use equitable recoupment as a defense against Associates' foreclosure complaint. The case was partially affirmed and remanded.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.